Welcome back to Cordell Cordell's webinar series regarding COVID-19 and the impact it has on divorce for guys before, during, and after, and including, most importantly now, child support modifications. I'm Scott Trout, CEO of Cordell Cordell, and we wanted to bring this webinar back to you from last week. We did our inaugural webinar series, and it was such a success, and we know things are changing on the fly, not only hourly, every day, and every week. We just thought it would be more important to bring this back to you and to bring you a new panel of attorneys from around the country that here at Cordell Cordell, as you know, we're the largest domestic family law firm in the country, not only here in the United States, but also for viewers in the United Kingdom with our offices in London. We've been doing this for over 30 years now, representing guys before, during, and after divorce and representing them in all facets of family law. So keep in mind, I'm licensed in Missouri, Illinois, and Georgia. I'm going to introduce to you my panel here shortly, and be mindful of the licenses that they have. Don't take this as legal advice. We don't want this to create an attorney-client relationship either. We want to make sure these are speaking points for you that you can take to your lawyer, that you can make some notes today, and hopefully get you some information to just have a conversation about what you can do. Remember last week, if you tuned in, we talked about what can I do, what should I do, and what must I do? Those three questions hopefully will continue to carry the day as we go through these points this week. So this week we're going to bring you a little bit more of a technical legal issues for you, give you some of the law, give you some of the things that you should be doing and what's available for you to do to kind of correct your situation. You know, with today's news, there's about 10 million of you that are unemployed, a staggering figure dealing with COVID-19. It is truly unbelievable, and we know many of you are hurting. And so that's why we're here to give you the information, to give you some resources, and to give you a path to try to get some relief. And so keep in mind that many of you last week submitted questions online to coronavirus.divorce@cordelllaw.com. We're going to address some of those questions with you today, but I encourage you to continue to submit those questions. We're going to specifically, I'm cutting new podcasts every day, different from this webinar. I want you to go ahead and find those on our YouTube channel. We'll address those. I'm going to devote 2 days, 2 podcasts, 2 videocasts just to answering your questions. So again, I encourage you to tune into those daily podcasts where we'll be spending about 20 minutes just on very small issues so that they may affect you. Do a search. Find those. We can get you some, again, those resources, some educational information, and perhaps some tools and equip you to get the help that you need. So let's turn to our panel for today. We want to kind of get you, the goal today was to kind of get you the corners. So we'll have someone, and we'll introduce to you right off the bat, California. Jason Hopper is back and returning to help you and answer some questions for guys listening out there. Again, Jason's licensed in California and Indiana. You've seen him on the Wall Street Journal in those interviews and last week in the local Fox affiliates. Welcome, Jason, to the show again. All right, turning over to Kim Gray up in New York. We wanted to give you the epicenter of what really has been the issue regarding the COVID and been impacted so significantly. Kim is a regional managing attorney in our New York office and is licensed in New York and Tennessee. Welcome, Kim, to the show.
Thanks, Scott. I'm happy to be here.
Joining us with a different perspective with regards to stimulus, that tax refund that you're going to get. Most of you out there have a lot of questions on, is Misty Dennis down in Texas. Misty is licensed in Texas and has been a board certified family law specialist by the Texas Board of Specialization. Also brings to us a master's of law. So welcome, Misty.
Thank you, Scott. Glad to be here.
And then rounding out our panel for the day, down in Florida. Again, a trouble spot with a lot of questions being sent in to our email is Amanda Diplin, licensed in Florida. Amanda, welcome.
Thank you. I'm happy to be here.
So the best place to start off, we've seen a lot of questions coming in. We're getting a lot of calls from around the country. Keep in mind, we're still open around the country. We are doing virtual and telephonic consults with guys around the country. Some of our offices throughout the country are in fact taking in-person consults, but we know what's important is your health and safety, as well as the health and safety of our attorneys and staff. So we want to make all of that available to you, but there are certain places that it's not. We want to talk about what guys can do. Many of the questions that have come in have been asking our attorneys both through email and through those consults are, look, can I even file? Can I file around the country? What can I do? What's available to me? So let's turn to Jason out in California, which was kind of an early adopter of the shelter in place where we had courts being closed. Jason, guys want to know, what's the next step? Can they file something, whether it be for divorce? Can it be for child support, emergency orders? What is it they can do out in California?
So the best answer I can give you Scott, is it really depends on the county where you reside. Almost statewide, we're seeing courts restrict access to the courts, certainly for in-person filings. A lot of our courts have adopted a Dropbox policy where new filings can be submitted. They'll be file stamped when the shelter-in-place orders are resolved. That being said, our courts across the state are welcoming emergency and domestic violence restraining order filings. The processes are going to vary on a county by county basis. Some are going to be handled electronically, just through email and through the pleadings. Some are going to be handled through conference calls, and some are going to be handled via Skype or Zoom.
Thanks, Jason. Hey, Misty, down in Texas, what's going on down in Texas for guys that are watching right now in that state? Is that something they can do? If they say they want to file a divorce, they need an emergency relief, or they need some relief on child support, which we're going to go back to Jason later on. But Misty, what's going down in Texas? Tell our viewers what's happening.
Well, in Harris County, which is the primary county down here in Houston, you can still file petitions for divorce, motions to modify, and especially emergency hearings. Because we utilize what we call an e-service system where we're basically emailing everything into the court, they are still accepting filings. And believe it or not, even though we can file cases, they're still setting cases for hearings, even though they're a little further out than we would prefer, which is understandable under the circumstance. The courts are still functioning very much as usual, except they're not hearing matters unless they are emergencies. So in situations where people want to get petitions for divorce filed right away, we can file them right away. They can get file stamped, and you can get that statute of limitations or that limitation period running, so that whereas there's normally a 60-day waiting period from the point you file your petition for divorce until the divorce is finalized. If we file now, you're cutting down on that waiting period rather than waiting until the stay-in-place orders have been lifted. So we are fortunate in that the courts are still allowing us to file petitions of any sort at this time, even though all the hearings are not being conducted currently.
You raise a good point, Misty, when it comes to why should guys be filing right now. There are a whole number of issues depending upon the state they're in, whether timelines should be going, whether they need to start. We'll talk a little bit later with Jason about retroactive child support and modifications. There's timelines that are important for guys about why they should take steps right now. But let me go down to Florida. Amanda, can guys file in Florida right now if they need to file for divorce or modification? What's the situation with the court system down in Miami and particularly around the state of Florida?
Scott, the Florida courts are taking filings. We've done filings here. We filed things this week. We're able to open up cases. The courts are moving to a video conferencing platform. The judges are actually doing training this week, and they're doing their test models to ensure that the hearings that are going to be scheduled are working. We've had plenty of case management conferences, our current cases being set for a couple weeks out. So judges are absolutely making themselves available. They're working on the whole Zoom and video conferencing. I've had telephone conferences with the judges that have been scheduled. So even if the video conferencing platform is not up and running for certain judges, we're still able to get a hold of them by the phone. A lot of the judicial assistants are also allowing us access by email, which was not typically available before. So we are having access to the courts and we are able to file. And so it is important, just like Misty said, to file as soon as possible, depending on the situation, because timelines do start to run. And those are important for different aspects of the divorce cases.
Thanks, Amanda. I now want to go to Kim up in New York because things on the ground up in New York, as we all know, and we're watching around the country, the tragedy that's going on and the terrible situation. And I know just off camera, Kim, you and I were just speaking about the different situation in New York and the access to courts, which really is shocking. But I want you to talk about what's going on and the ability with courts access. But more importantly, Kim, maybe you can talk to guys as it relates to that, why it's important to get a consultation now if they're either facing a divorce, considering it in the middle, or even thinking about a modification.
Sure. So yes, in New York, it is a little different right now. As you know, New York City is pretty much the epicenter of all of this. And as such, there has been an order entered on March 22nd that prohibits all filings. So we can't even file anything with the court unless it's an emergency. There is a short list of pleadings and filings that we are able to file if needed. And most of those are related to emergency matters. It is still important, though, to talk with an attorney and to file for and to get your divorce paperwork prepared. Even though we can't actually file it, there are things that we can do. We can prepare all of the pleadings. After this all ends, there will be an influx of cases being filed here because they're not accepting any filings now. And we want to be at the front end of that. We want to have the paperwork already ready. We want to be able to just put it in the mail and be ready to go. So I think it's very important for guys to come in. Let's get the information. Let's get the paperwork prepared. There are even things that we can do in the meantime while we are waiting for all of this to end. We can fill out the financial paperwork that's required in New York. There are lots of different affidavits and paperwork that we need to prepare as it relates to financials. We can get that ready, so we're ready to just submit and go when it's time. It's also important to start working on negotiations. I mean, even though the courts are closed and we can't get into a judge, we can still engage in settlement negotiations. We can prepare proposals. We can mediate. So there are lots of things that we can do in the meantime while we are waiting for the courts to give us access. And it's very important that we're prepared so that when we are granted that access, we can jump in with both feet and get going.
Thanks, Kim. Hey, Jason, thinking about this, about continuing the process and maybe the importance of what guys and why they should file now, maybe you can talk just briefly about why it's important to not wait under certain circumstances, perhaps even on a modification of support or even a divorce. Why should guys take action right now? Not only that, just to file, but to seek the advice of an attorney.
Yes, Scott, it's really important and it's really understandable given the circumstances that we're all facing. It's understandable that one could fall into a procrastination trap. Life's getting in the way. You might have anxiety of a prior court appearance. Things didn't go the way you wanted it to. You're concerned about rocking the boat, or you might think that your unemployment situation might be temporary. It's really, really important to use some common sense here. Retroactivity is really the key concern that we have as to encouraging clients to seek relief now versus waiting 2-3 months till this all shakes itself out. Under California's family code, retroactivity is available. However, if you're seeking a modification of, let's say, child support, the retroactivity, if it's due to loss of employment, it can at times be made retroactive only to the date that you notify or serve the opposing party, unless the court finds good cause. So that good cause exception really falls into COVID-19 related job loss. If you wait, I think that it opens the door for the court to use their discretion to say, well, you chose not to file, you chose not to seek relief. So we're not going to retroactively apply this really until we get back into the status quo of the courts being in full operations.
Yeah, that's a really good point, Jason, and the importance of really, and we'll talk later, and I know that's something I want to come to you on since you've raised it a little bit later about support and why it's important to do something now. You have legal rights sitting out there that affect retroactivity, establishing a new amount, and what happens to all that money that continues to add up as under these existing orders. So we'll come back to you on that. I want to go back to Kim when we talk about things that, what's going on with this backlog now that New York isn't accepting new filings. There was a question submitted to last webinar about, I'm in the middle of my divorce. What's going to happen? I assume it's going to be delayed. Is it going to just back up? What should I expect once things open back up?
Well, that is unfortunately true that there will be some delays just in the amount of time that we're able to, in the quickness in which we're able to get into court after it does open. But I think that just goes back to what I was just saying about things that we can do in the meantime while we aren't able to get into court to fully prepare so that when we are able to, we can go right in.
Yeah, I agree. So last week we talked a little bit about this, And just because courts may be closed in New York while they're open for filings and other matters, and they may not be open for in-person hearings, it just stresses the importance for your attorney to be making and having different conversations with you about moving the case forward so that when things do open up, you can proceed as quickly as you can. So it's a good point, Kim. Thanks for bringing that up.
I'd just like to add, Scott, that even though we can't file anything with the court, there are other things we can do. We can talk with opposing counsel. We can, try and negotiate different things. We can still enter into agreements and have them ready for filing. Family court will accept stipulations, but Supreme Court won't, which is where we do most of our divorces. But we can still negotiate. We can still use, the potential for filing later as leverage when we're dealing with opposing counsel and trying to get things to happen. Yeah.
Well, those questions, like the others we just covered, are exactly what was submitted. Good examples of what guys have questions on. So I'm going to continue to address those types of questions in the podcast. Just a reminder, I'm going to continue to point you in that direction so that we can answer all of your questions. Remember, submit those questions both from today and things that are on the top of your mind to coronavirus.divorce@cordelllaw.com. So let's go dig right into probably one of the more pressing issues, not only as it relates to filing, what can I do now, but what's really pressing on guys that's really coming up here in the next couple weeks, and that is, Misty, the stimulus money that's coming out from the result of the congressional action regarding the coronavirus, that $1,200 per adult, $500 per child. There's some questions for guys out there because if they're separated, where's that money going? Where's the IRS going to send that check? And if I'm not living with my spouse because either we're pre-divorce, in the middle of the divorce, maybe just talk to guys about what do they do proactively, where's that money going to go, and how do I get my share of it?
Well, the government is going to look towards your last filed tax return to determine where the money is going to go. So if you were divorced in 2018 and you filed, 2019, and you filed a joint tax return for 2019, the funds are going to go to whoever filed that last return. If it was a joint return, then the money's going to go to that last address or wherever it was you filed that last return. If it was an individual return that you filed because you filed married filing separately, or you filed individually or head of household, then the funds are going to go to whoever filed that return. That's why it's important, or that's why they're urging people to have your 2019 return filed. If you have not filed your 2019 return, then they're going to look to the 2018 return. Obviously, a lot could have happened in that 1 year period of time. So if you have not filed 2019, it's a good idea to go ahead and get it on file, because that's the information that the government is going to look at in determining where the money's going to go. Another thing that it's important for people to remember is that everyone will not qualify for the stimulus money. There is a cutoff. Essentially, what's happening for an individual filer, if you earn more than $75,000 per year, it's going to start cutting off the funds that you're entitled to receive. So at $99,000 or more, you're not going to qualify for any of the stimulus funds. So people who make more than $99,000 per year don't expect to get a stimulus check. There are some circumstances, however, where even if you make more than the maximum $99,000, if you have a child and you have claimed that child as a dependent on your return, then you still may be eligible for that $500 check. And it's important to keep that in mind because it is the individual who claimed the child as a dependent who would be eligible to receive the child's $500 portion. So if you're separated or divorced and your spouse or your former spouse was able to claim the child as a dependent on their return for 2019 or 2018, if 19 wasn't filed, then that is the parent who will receive that $500 stimulus check. So a lot of information is still coming out about this. So it's important for you to continue to read it as it comes out, but there are some basic rules that are in place. And the most important rule to remember is the $500 check that will be received by the parents goes to the parent who claimed the child as a dependent.
So here's a really common scenario that we got a question on that's really what I call a frequently asked question, that is divorced. And last year in 2018, it was my wife's turn to claim the kids as a deduction. For 2019, it's my turn to claim the kids. I haven't yet filed. Where's that money going to go? If it's based upon the last known tax return, is she getting my money since it's really my year in 2019? And if it is, what should guys be doing right now to try to make sure that they either get filed or they can get their spouse to, or ex-spouse to cooperate?
They should file right away. They should file, or they should file whatever is necessary. Now, one of the things that they have expressed is that if for some reason you didn't qualify in 2019, either you hadn't filed the previous return, or maybe your income was too high and you didn't qualify, that they will make adjustments for 2020. But what will happen is, if you should have claimed the child in 19 and 2020 is the year for you to, for your spouse to claim the child, then you're going to miss out. So the most important thing for you to do under those circumstances is to file your return. Additionally, the IRS has a form that parents can sign, which will authorize the other parent to claim the child on their taxes. At the time of the divorce, typically here in Texas, we have the parents sign this form for future years. So if one parent's going to get odd years and the other parent is going to get even years, you can fill out this form, which basically authorizes you to be able to claim this child on your odd years or your even years. That's something that you may be able to rely on in future years if you hadn't filed your 19 return. The most important thing that I can tell you is, if this is your year to be able to claim the child, file your return as soon as possible. Even if you may have to file an amendment later for additional information or for whatever it is, this is the information that the government will be looking at in regards to sending and forwarding your stimulus checks.
So let's say they're separated and I couldn't get filed, or the money goes to the home where the mailing address was on our last return. Are the courts going to consider, and let's say my wife gets the money, she gets, $3,400, whatever it is the court going to consider that and as a marital asset for most states? And do guys have a remedy to get some of that back if their wife won't cooperate and give them some of that money?
Absolutely. And that's one of the things that I'm trying to encourage my clients now. If you're in the middle of your divorce, so you're separated, but your divorce is not finalized, and one parent is filing taxes individually, or married filing separately, and the other parent hasn't filed or doesn't have the benefit, then the courts can offset that. So let's say, for an example, your wife files a return, claims the child, and gets a $5,000 refund. You file, you don't get to claim the child, or you don't get to claim any property, and you have a loss. When we are dividing the estate in the end, we actually include that as an asset of the estate. That was money that belonged to the community, and that will be taken into consideration in the final division of the estate. And I've actually have seen courts take that into consideration, where one party received a large return or a larger return and the other parent hasn't, and including those funds in the pot, basically in the assets for division.
So that's great stuff. I know guys have a lot of questions, and it's just another reason to encourage you to come and have a consult via the phone or virtual. We can do it via Zoom. Thanks, Misty, for that information. So let's move real quickly to one of the other pressing issues that last week we talked a little bit about, and that is, I'm going to go to Jason in California. Jason, child support, 10 million guys, 10 million people out of work. We know that some of them, a good majority, have a court order for child support, and now they can't pay it. So tell guys out there two things. What is it required, what we call the standard of proof, but what that really means is, what do guys have to prove in order to get a decrease? And typically, what would you suggest the type of evidence that they need to provide in order to put themselves in a position to get that decrease?
Yes, Scott. So in California, we're kind of the exception to the rule. California has what's called a change of circumstance obligation. In a lot of our sister states, there's an accompaniment of a substantial change in circumstances, but a continuing change in circumstances. So we don't have that standard in California. So, for any folks out there that are listening to this, first off, you have our empathy as to, how the number one, we're dealing with the concerns from a medical perspective, but now we have concerns from an economic perspective. But all that we need to demonstrate is a change of circumstances, and job loss or reduction in pay or furlough or even a loss of overtime, if that was factored into your existing obligation, those are changes in circumstances. We talked a little bit earlier about the concept of retroactivity, and that is absolutely very important. The other approach that I would take to this, and that I'm encouraging, and we've seen an explosion of these cases just in the past 2 or 3 weeks, is utilizing the meet and confer efforts that you're required to make anyway in California. We've had a few instances where where the other side has been reasonable. They've appreciated the fact that there is job loss, and we're working in language into our stipulations that although we can't necessarily get an order from the court, we can include language which specifies that the modification that the parties are agreeing to is immediate. And including that type of language and working with an attorney who really knows how to craft an agreement that can work for both parties really can be to your advantage and really save you a ton down the road as far as potential reduction of arrears and certainly reduction in your ongoing obligation.
So when guys are looking to reduce it and they come in and we file a motion to modify, what is it that they need to show? We talk about just a pure loss of job, but what is the evidence? They're thinking, okay, what do I need to gather right now? Do I have enough under the change in circumstances in California? Just what kind of evidence would you suggest that we're going to present to the court to get them in that right position?
Yeah, so in California, with any financial related issue, litigants are required to file what's called an income and expense declaration. Typically, that declaration is supported by recent pay stubs, maybe a prior year W-2. In an instance where we have a job loss, we want to try to get some documentation from the employer that verifies maybe a termination letter, maybe a furlough letter, something of that nature to document the change in circumstance. We absolutely can prepare and should be preparing income and expense declarations. Even if we can't file them, we can exchange them as part of our ongoing meet and confer efforts.
So
that's the best advice I could give.
With the evidence that they would submit, are there experts that you've used that guys should be considering and at least asking their lawyer to consider? For example, I've used a vocational rehab expert. Tell guys what that is and the advantage perhaps that expert would bring to assist them in getting a modification.
Yeah, so one thing that we may see is, let's say you're a guy who has a child support obligation and your ex loses their job. Or maybe your ex is in a position where they're an essential employee, but they're concerned about the potential of contracting disease, and they voluntarily put themselves in an unemployed situation, or they take advantage of the new expansions of the FMLA. So what a vocational expert does, or a vocational evaluation provides, is we look at national data and local data through the use of this third party. To determine, okay, what could this person be earning given the current job market, given their training, their education, their history. And if we run into a situation like that where a person is voluntarily unemployed or voluntarily underemployed, we can utilize that information to then impute potential income to the person who is unilaterally made a decision to become unemployed. The support obligation is calculated in large part off of your income or your potential income in the case of a person who's become voluntarily unemployed. So we certainly in the appropriate case, we'd make use of that. I actually was just on the phone yesterday with a vocational expert, and she said that her phone is ringing off the hook, with ongoing concerns. And so, the message that we want to provide to the guys out there who are being affected by this, either as a result of your job loss or your former spouse or co-parent's job loss or reduction, is that we have tools that are available now, and you don't need to wait 2-3 months to see how this all shakes itself out. We can seek relief now.
Yeah. Hey, Amanda, out in Florida, now we know kind of the California, which perhaps is a different standard. what's the standard of proof, what we would call, what do you need to show to get a modification of child support in Florida?
So in Florida, we do have a substantial change in circumstance standard of proof to show the court. The substantial change can be a change of income to either parent. So if there has been a change of income and it would result in the child support being modified by $50 or 15%, whichever is greater, you would be able to modify. So that's a little bit tricky, right? Because who's going to know whether their child support is going to be changing by $50 or by 15%? It's something that the attorneys have to look into the financial situations of both parties and almost run child support guidelines. So the sooner that we get information, the sooner that we're able to file for a modification in the state of Florida, the better. The date of filing the modification is going to be the date that we're able to go back retroactively. So I know that Jason was talking about that the courts have a little bit of leeway up there, but over here, generally, it's to the date of filing. So if you're unemployed for 2 to 3 months, don't wait that period of time. Call us immediately upon your unemployment so that we can get that petition for modification in, so that way, unfortunately, if your case is not heard by the court for weeks or months because of this whole pandemic, then we at least have that petition filed so that when the judge does hear your case, we can apply whatever the modification is retroactively to the date that we filed the petition.
So retroactively, for guys who are out there, of course, we always use these legal words, but meaning that, look, if you have a $500 per month award and you file and it's going to go down to $100, that difference will be retroactive to the date of filing, means you get a credit if you're paying the full amount. So, Kim, up in New York, really the question becomes, do you see judges historically being understanding? I mean, probably now more, but if you kind of look back into the recession time in 2008, where judges up in New York, even now, more understanding of just losing your job being enough to justify a change of circumstances or a modification of child support up there?
Well, judges do look at a substantial change in circumstance, but what we're really looking for is at least a 15% change in income before we can modify child support. Courts in New York will also look at modifying child support every 3 years. So if we do have a situation where there is a job loss, then obviously you would probably have a 15% decrease, and then you would be able to modify child support at that point.
So it's a good point. Guys have often, no matter the state, that, with me in either Missouri, Illinois, or Georgia, they've always said, well, I've heard I can only modify once every 3. That isn't necessarily true if they can show the change or substantial change in circumstance, right, Kim?
That is correct. It doesn't have to be every 3 years. As long as we have a change in circumstance or a 15% change, those are 2 other reasons why we could go for a modification and not have to wait for the 3-year period to run.
So Jason, here's the question guys want to know. I've lost my job. I'm supposed to pay $500. I can't afford it. I don't have any in savings. I'm not getting a paycheck. I've got a week delay to get my unemployment. Even that's not going to be enough to pay my bills. What do I pay in the interim? What do I do to do my best? Should I pay anything? What should the guys be paying right now?
So, certainly pay what you can. I think that's important. And if you find yourself in a situation down the road where you've chosen not to file anything right now, but you've also chosen to voluntarily reduce your support obligation, I wouldn't advise doing that. But create a paper trail with the other side. Reach out to your co-parent and say, look, here's the situation. I've lost my job. My plan is to do X, Y, and Z as pertains to my ongoing obligation, as to any arrears that I might have. If you find yourself in front of a judge 3-6 months from now, in trying to explain why there has been less than the court-ordered amount being paid, you can at least demonstrate, look, I made proactive efforts to do this. Preferably I've used an attorney to file a modification request. It can really avoid a willful violation of an order, given what the circumstance might be. Mm-hmm. But I would say more than anything, pay something.
Right. And that's really the advice I've given, is find something, keep good records of what you're paying. Don't accumulate a savings, obviously, or don't go buy anything lavishly. You're not going to do it anyway, but pay something to show, to keep yourself out of what we call contempt and contumacious disregard, right? It's kind of those legal words. So thanks, Jason. So, the same would go for alimony. In those same considerations, there's different things to look at in your decree. We talked a little bit about that last week. That's another reason to contact an attorney to review the terms as it relates to alimony or maintenance or spousal support, because those get a little bit more technical depending upon the language in your decree. So I encourage you to set up a consult. Again, questions like that we just covered, they'll be covered in our podcast. Submit your questions to coronavirus.divorce@cordelllaw.com. We'll try to get to those during our podcasts that we're having daily moving forward. So let's continue when we talk a little bit. I'm going to go to Amanda down in Florida. Not only but child support, but you hear some news and some articles around the country, whether it be on some of the large stations, that where guys are not getting the custody or visitation that's court ordered. Whether mom is saying, I'm afraid to let my child out, your house isn't safe. What can guys do right now in Florida if they're being denied and they haven't seen their kid in 3 weeks? What can they do? What can they file with the courts in Florida right now?
So we can file an enforcement action. There's a court order. Court orders are meant to be followed. So we would file contempt action as well as an enforcement action. The contempt is basically letting the court know that there's been a violation of the court order that's in place. And the enforcement action is to get the court order to have the other side follow the order that's in place. So we file those together to get the relief ultimately that we want, which is to get visitation according to the court order that's in place. I would also immediately start to contact the other parent. This is all child related. The court is going to consider the best interest of the children. So we want to make sure that the time sharing and everything is in the best interest of the kids. We want to make sure that the dad and the mom are both offering a safe environment, that everything is clean, that nobody has been exposed to this pandemic, to this virus, and is asking for time with the kids, because that is something that the court will consider. I would let the other parent know immediately that you want this time sharing. Remind them that it is your child. You're providing everything. You want the well-being for your child. That starts to create a paper trail. If the parent denies, and that is all used in evidence based on that parent's lack of wanting to co-parent and wanting to follow that court order. But legally with the court, we would want to file a motion for enforcement immediately. We can get that in with the court. We are accepting court filings. The courts are giving us hearing dates. They're doing video, they're doing hearings by Zoom, they're doing telephonic hearings. So there is legal remedy to get these orders enforced. We just have to get it done quick so that this other parent doesn't get used to not having to comply, and then more time passes between dad can see the child.
So we talk about the evidence, the standard, and filing an enforcement action. So I assume, and we mentioned this last week, you would recommend no phone calls, do everything in writing, via text, via email, right? Something that you can produce in court to show that you've tried to, take advantage of your rights and exercise them, right?
Absolutely. Send emails, send text messages, send messages on WhatsApp. I would even recommend to the dads that the moms have completely cut off any communication. Make those phone calls and screenshot your call log where it shows that mom is not answering the calls. Those are obviously in a little bit more extreme circumstances, but I've had clients do that, and then we'll show that mom is not even taking calls, not even allowing that FaceTime with the dad during this period of time, and that can be used as evidence as well, in addition to the text messages and emails.
So what's the court likely to do if you file enforcement? Really, what is what we call their remedy? What can they give guys who've already lost some of their time? I mean, keeping in mind, we have Easter for some coming up next week. We have summer visitation. We don't know if this is going to last throughout the summer. So some guys have equal time in the summer. What is the court going to do for guys like that when they've lost all this time because mom has just decided it's just not some time to exercise a visitation?
So whenever we have a time period where a client has not been able to have time with the child, we always ask for makeup time sharing. So whether that makeup time sharing comes in the summer, if this is all over in the summer, or in the winter break, or even next summer, if the dad has to get a larger period of time, then so be it. We need that time to be made up whenever the child can. If the child is not in school, then it can be sooner rather than later, and school doesn't really necessarily affect it. But we always ask for a makeup time so that the dad can be made whole from the time that was missed.
Misty, down in Texas, kind of listening to Amanda, the same type of remedies available to guys in Texas who may be denied custody, even contact sometimes, or exercising their full rights with an order. Is that happening in Texas, and what are courts regularly doing right now?
Absolutely. And I can say that the Texas Supreme Court has been very, very proactive in regards to people violating visitation orders. The state of Texas, the Texas Supreme Court has issued almost 8 separate emergency orders as it relates to possession and access. So the initial order came out when the children were being forced to stay home from school. Spring break is a period of time in Texas where the parents alternate. So one parent may have spring break this year, the other next year, and then at the end of the spring break, the parents switch. Well, here in the state of Texas, the kids didn't go back after spring break because of the coronavirus epidemic. So what we were seeing was that parents were deciding, well, I'm just going to keep the child since I have them, and the other parent is not going to be entitled to access to it. Very quickly, the Supreme Court issued an emergency order that directed parents to exchange the children at the end of what would be considered normal spring break. Shortly thereafter, the Supreme Court issued an order that said you're going to continue to exercise your periods of possession as if school is in order. Because again, constantly parents were attempting to violate the order because the school year schedule had been changed. Most recently, the Texas Supreme Court issued an emergency order that said, even though we have a stay-in-place order in the state, in Harris County and the surrounding counties, you still must follow the terms of your existing court order. You can't use this stay-in-place order to deny possession and access. So the remedy that we have here is called a writ of attachment, where a parent is preventing the other parent from having access under the gaze of, hey, we have a stay-at-home order, or the kids aren't in school, or whatever it is. We can immediately file a writ of attachment. That in Harris and the surrounding counties is considered an emergency order, and the type of hearings that the courts will conduct right away, typically within 2 or 3 days. And the courts are exercising their right to do these via Zoom, as well as FaceTime and these other apps to prevent people from coming in court. When people are violating these orders, the punishment to the other parent is fines and attorney's fees, as well as sanctions. If you have to file a motion for enforcement, which takes a little longer in the process, then we absolutely are offering the courts are absolutely offering makeup time for the parent who is lost off, as well as punishing the other parent for failing to follow the terms of the court order.
So Kim, up in New York, we talk a lot about right now guys who have a court order, but there are many guys watching right now that are in the middle of the divorce, or they're pre-divorce, they were just contemplating it, they don't have an order, they're separated. What do? They're being denied. What's New York judges doing? What should they do right now when there's no order in place? So mom's just saying, look, I don't have to give you any time or custody, probably maybe even no contact, because no one's told me I had to. What do guys do?
Well, when there is no order in place, that does make it a little more difficult because there's no order to enforce. However, there are still things that we can do. We all have to remember and think about that when we do get to court eventually, and we will because they will open again, the courts are going to take lots of things into consideration when determining child custody and parenting time. And one of the things that they're going to be looking at is the behavior of both of the parents, the ability to facilitate in a relationship with the other parent and that other child, and the facilitation of those visits. And then if a parent was denying parenting time, was trying to leverage this COVID to allow them to have more time or to cut the other parent out, that's not going to be looked upon favorably by the judges. And we would use that definitely when we're asking for more time when we get an order. Yeah. So I think that's really important, just to all remind opposing counsel of that. Send out a demand letter saying, we need this parenting time. This is what we're requesting. We need to come up to an agreement because this is not going to fly when we go to court.
It's important that guys should be proactive, that if they're not getting the custody, they don't have an order, even if they do have an order, I assume they should be sending emails and messages saying, I'm available, I want to exercise my custody, kind of what we say, kind of paper your case and prepare. And that'll be great evidence, I assume, right?
Yes, definitely. I always tell my clients to keep a journal, logging exactly when they have their child, If they don't have their child, if they were refused, log that. Log any text messages that they have sent, just like Misty said, the phone calls, if they're going unanswered, FaceTime calls that are going unanswered. Document everything, log everything in their journal, keep that journal up with them on a daily basis, because it's easy to forget specifics. And if we have that calendar where it's telling you every day what you did, what efforts you made, what was denied, and when you were successful, that will definitely help you when it's time to go back to court.
So Jason, one of the questions that came in last week was, mom is saying it's too dangerous, either in my house or the environment, just sending them out to do any custody exchange. I mean, I assume, what would you tell them to do right now if mom's claiming their house is unsafe?
So the first thing I do, Scott, is reference in my jurisdiction. Okay, has my court weighed in on this? And we've heard from Misty and from Amanda, that there have been some interim orders issued by the courts in their jurisdictions. One of the great things about working in this firm is that we have a nationwide network of colleagues, and we've had a really good discussion nationwide internally in sharing what various jurisdictions are doing. There tends to be some uniformity that I'm seeing, and it's really started with some guidelines that were issued by the Association of Family and Conciliation Courts in mid-March. And what we've seen is mirrored, in every jurisdiction that we've heard from, is that if there's an order, or even if there's not an order, if there is a guideline in place, those guidelines absolutely should be followed. And so what I would reference, if I'm a guy in a jurisdiction where, let's say our local court hasn't issued a guideline, one thing that I would plan on doing, if one of my counties that I practice in haven't issued a specific guideline, is let's cite to, okay, in Sacramento County, here's what they're doing. Here's what the AFCC is saying to do. Here's what they're doing in 35 other states, which tend to be pretty uniform in that if we have an order, it needs to be followed with really little to no exception, absent an emergency circumstance. And we've heard today about, there is availability to seek emergency relief if there really is a life or death situation to facilitate the visit. Outside of that, making a robust meet and confer effort to ensure that the visitation can be facilitated, and if it won't, counsel the client as to seeking emergency relief, because those are emergency situations if they're going days, weeks, months without seeing their child.
Coming back to you, Kim, and then we transition, because I know there are questions about when this is all done or what's happened changing custody, but there was a question submitted about being exposed to potentially the virus that they may have been, or their kids that are living with them. Can they decline visitation with their ex-spouse if they fear that they've been exposed, and will that declination be held against them? Are there any repercussions if they have a legitimate medical or safety concern if they decline visitation?
I think if there is a legitimate safety concern, I think it would depend on what they think is legitimate. I think a problem that we see is that a lot of people think that what their concern is legitimate when it's actually not really all that legitimate. Parents are deemed to be appropriate, and they're deemed to be able to make appropriate decisions for their children that's in the best interest of their children, and that's both parents. So, the mom just can't say, oh, I think that you're not going to safeguard our child, so I'm going to keep our child. The father is deemed to be just as good as safeguarding the child, and he's presumed that he's able to do the exact same that the mother is. So she can't really say that, I'm going to keep the child because he's at risk with you. He is not at any more risk with the father than he is with the mother.
So Kim, thinking about things that occur during this COVID outbreak and maybe bad decisions that mom may make, or the ex-spouse may be making regarding custody, what is the standard in New York if guys out there are thinking, I was divorced, I don't agree with the way mom handled this situation, she repeatedly denied me custody. What is the standard for modifying a custody order in New York right now?
Well, there has to be a substantial change in circumstance, and you also have to look toward the best interest of the child. So if there is a substantial change in circumstance, then that would be the first thing that you need to plead and prove when you get in court. And, there are lots of different things that can be a substantial change in circumstance. If your child is not school age and they become school age, and that could be a reason for a modification. Treatment of the mother as far as decision making and perhaps not including the father in the decision making. That could be a reason, a change in circumstance. Lots of different things can be changes in circumstance that could result in a modification. And after we prove that there has been a change in circumstance, then we also have to prove that the new arrangement is in the best interest of the child.
Amanda, on the same topic, I guess the question, when we think about modification, but there are a lot of guys out there where custody hasn't been decided, they're in the middle of their divorce. It really is, what is the standard in Florida for a judge? Kind of what do they need to prove, or what do they need to consider when determining custody? Because guys out there right now may be thinking, you know, I was thinking about an equal timeshare with my kids, but now looking at the way mom's handled this situation, I want custody. So what is the standard in Florida right now that the courts are going to look at for guys so they know the direction they need to go and what they need to begin to prove?
So the judge is going to look at the best interest of the child. If mom is not acting accordingly, if mom is not being reasonable with any decisions that are needing to be made right now on behalf of the kids, dad should be documenting that. Not only that, dad should also raise objections to whatever actions he doesn't think mom is doing appropriately. So if something happens and dad doesn't think mom handled it appropriately and it got back to him, don't just write down that that happened, but also shoot her an email, say, hey, listen, I found out that this was done. I don't think that it should have been done that way. We need to co-parent. We need to figure this out because it wasn't done properly. That way that he's raising his objection so that the court knows that immediately upon him being aware of something that wasn't handled appropriately, he said something to mom and didn't just, stay quiet and just raise it in front of the judge. That's very helpful with the judge to understand that dad means what he says and that he wants more time because of issues that have been happening over time. And he's also been documenting it and addressing it with mom whenever it happened.
So Kim, guys out there, whether it's a divorce or a modification, there are a lot of questions about who they can have testify for them. They ask, can I have teachers? Can I have doctors? Can I get medical records? How about neighbors, friends, even mom's parents? Are any of those worthwhile, and will a judge consider any of those as evidence, or will they consider them testifying, whether it's a modification of custody or seeking an initial award of custody in a divorce?
Absolutely. All of those are great options for testifying. We frequently have teachers, doctors, counselors, therapists, even friends and neighbors testifying about what has happened. And friends and neighbors really only if they've actually seen the parent with the child on multiple occasions. Occasionally you can use opposing parties, relatives. You really have to vet them first to make sure that that they really are going to be on our side. But absolutely, all of those people would be people that would be great to have testify to use as evidence. Other things that we can use as evidence are, school records. So not just having the teacher come and testify, but actually having the school records submitted to the court, medical records if needed, if the child or one of the parents is in counseling or therapy, getting those records and presenting those to the court as well as evidence to show the best interest test. All of those things are things that we frequently use and that are very valued by the judges.
Jason, back to California, modification or divorce. Guys always say, I want my kids to testify. Can they in California?
So California uses a very robust, what we call our family court services program. So each county in California has basically a guardian ad litem, which is what the person would be referred to in a lot of other jurisdictions. So they're actually an employee of the court. In most counties, if a child is of a sufficient age, and it varies on a case-by-case basis, but generally kids over the age of 8 are invited to participate in that family court services process where their input is provided. In almost every jurisdiction, the input of the child is a factor of the several best interest factors that the court will consider. Obviously, the preferences of a 6-year-old versus the preferences of a 16-year-old are going to carry a lot of different weight depending on the circumstances. But yes, kids are in California specifically are a part of this process, and typically they will be interviewed if they're of a sufficient age.
Misty, down in Texas, any differences with kids testifying down in Texas?
Yeah, so the courts here really would prefer for children not to testify. At the age of 12, a child can express their preference to the court, but that is typically done in chambers and not in front of counsels or parties or anyone else. And that expression of their preference could be recorded or it could not be recorded. It depends on the judge and the circumstances. Now, in cases where children are under 12 years old and are essentially too young to express their preference, then the courts do appoint amicus attorneys to represent the interests of the children and to do some research and some background into really what is their best interest. The primary consideration in the courts here are the children's best interests. So even a 12 or 15-year-old child can express their preference, but if the court deems it's not in the child's best interest for their preference to be put into action or to be recognized, and the courts still have the ability to deny that.
Amanda, real quickly on an issue that's pressing for guys that don't have a court order, they're in the middle of the divorce. Can they file a motion right now? Is this something where the Florida courts would entertain a motion to get some sort of order in place to either get them custody or get them visitation right now?
Absolutely. The courts are operating on a video conferencing platform, so we can have a motion filed electronically and try to get a hearing with the courts as soon as possible so that the court can make that order so that we can get a time sharing plan in place immediately so that nobody misses out on time with the kids.
Kim, last thing on this custody issue, we've all talked about guardian ad litem and GAL. Does Texas have such a thing? And really quickly, just explain to guys what that is, what a guardian does, if that's appointed or it's something they want to do.
I'm sorry, was that Kim or Misty?
Kim, I'm sorry, Kim.
Thank you. Yes, in New York, attorneys for the children are appointed. So it's similar to a guardian ad litem, but in New York, it's called an attorney for the child or an AFC. Those are appointed either by request or whenever there is an allegation of abuse or harm or something like that. The attorney for the child does interview the child, interview the parents. They watch the parents with the children. And they come up with an opinion and they present their opinion to the court as to what they feel is in the best interest of the child. You know, an AFC can have pros and cons. You know, an AFC, if you have the AFC on your side, then it's a great thing. The AFC will tell the judge exactly what he or she thinks, and the judges here will typically go along with what the AFC thinks, what the AFC believes is appropriate in the case. You know, it can be some work sometimes when we are trying to get the AFC to understand our position or when we're arguing against the AFC. But they are wildly used and always in family court for sure.
Thanks. Hey, Jason, to kind of close it out for today, one of the viewers asked, you know, the CDC recommends against non-essential travel, meaning on an airplane, but this viewer lives in another state, has custody, and wants to know if they should be putting their child on an airplane to give mom or ex-spouse some custody that's court ordered.
I think the best answer I can give is it really depends. I think that with that, I mean, if I were in that situation, I'd be very uncomfortable with putting a child on an airplane right now. And I would think that, you know, most appropriate parents would feel the same way. This is a prime example of utilizing meet and confer, you know, trying to have some line of communication with the other side, and if necessary, seek out emergency relief. If specifically, if your child has any type of pre-existing health condition, or just the fact that there's air travel, you know, the guidelines that are in place are that visitation is to occur as ordered. So really your best relief, if you're in that circumstance, is to seek out the emergency relief protocols that are available to you.
Yeah, and I think also just to kind of cap it is to make sure you're communicating with the other parent and saying, look, are you comfortable with me sending, you know, Johnny on an airplane to come visit you? And if they say yes, I think we're good. Don't you think, Jason?
I think so, yeah.
Good. Well, hey, panelists, I thank each of you, and I know everyone else around the country does as well, for joining us today. That will do it for our second edition of the webinar that we've done nationwide. Make sure to tune in next week. We're going to bring you more information as it relates to COVID-19 and how it impacts guys around the country facing divorce, in the middle of divorce, or perhaps even after or at the end of the divorce. So don't forget that if you need some consultation, need some advice, that we're available telephonically, virtually. You can give us a call at 866-DADS-LAW, or you can go to our website at CordellCordell.com. And don't forget to submit those questions to coronavirus.divorce@CordellLaw.com. Again, tune into the podcast that we're doing daily. There'll be a few of those podcasts dedicated just answering your questions to the best that we can. So I want to thank Lexicon for helping produce this, as well as Spot. Make sure to tune in next week, and until next time,